Change a lot of those statutory authority. Okay. At the last meeting, again, we discussed the three rules. We had very good comments. They've been redrafted. You have them. So let's kind of pick up where we left off. Are there any other comments before I get going with the detail? Mr. Bond.
I have one comment. I have to go backwards, but that was brought up in discussion on the redraft on the very first one that we talked about engaging in business. And although it's a rule that references specifically part of 43.3, the way that it's written probably needs to include some sort of language that says that, or acknowledgement that in no way applies to caregivers. The reason that's important is, and without starting a whole discussion on this, many of the local governments that are looking at how caregivers are located in their municipalities may view them as home occupations, and as such, that is technically engaging in business. So making clear that caregivers aren't contemplated in that part of the rules engaging in business, I think makes common sense. It's probably obvious, but probably needs to be stated as well.
Okay. And again, the three that I passed out, I wouldn't expect everybody at the table to chime in on it. This is by no means in stone, but we'll take those comments at our next meeting and discuss them in depth. Thank you. Any other comment?
The only thing that I would add is that one of the things we talked about at the local government level, and I know it's important to the state as well, is, and it's important to everyone that's either already operating or hopes to be operating in July, is of critical importance is dealing with rules that relate to licensing and licensing issuance, because right now local governments are waiting, those that are planning on licensing, to see what the state rules look like, because unlike the liquor code, municipalities and counties will have very broad authority under 1284 to be more restrictive or different in many ways. So to the extent that the rules are dealing with licensing, which is going to be sooner rather than later, are complete and comprehensive, that saves the local governments a lot of work if they don't have to be adding things in their own ordinances for licensing and operation. So to the extent that we can move those to a higher priority, as we're talking about it, I think is important.
Okay.
And I think the other comments I will fit in where we start talking about specific issues.
Thank you. And for the record, we'll probably get through the lion's share, at least my side of it, but I'm hopeful that through these subgroups and committees, that if there are voids, that we can bring them back to the next meeting. And for the benefit of the people in this room, I'm starting to get a number of calls from local government relative to that very issue. They're looking for some guidance. So whatever we can do to facilitate that process will help the industry as well. So we'll move those forward. Okay, we'll pick up on page 13. Duties of inspectors and police officers. This falls under the statutory mandate to promulgate rules defining specifications, duties of officers and employees of the state licensing authority. Inspectors of the Medical Marijuana Enforcement Division, their supervisors, will actually engage in performing their duties by acting under proper orders and regulations, shall have and exercise all powers vested in peace officers of the state. The exercise of their duties, such inspectors and their supervisors shall have the power to arrest. Such inspectors and their supervisors shall also have the authority to issue summonses for violations of this provision of this article and other criminal offenses found in Title 18 of the Colorado Revised Statute. For the benefit of the work group, the inspectors that work for the Medical Marijuana Enforcement Division are all post-certified. They meet the police officer standards of training for the state of Colorado. They are all peace officers by definition. And I really put this in for the benefit of the industry, very candidly, because under Title 16, we already have this authority, but I want it clear in light of some of the comments that were made specifically during the legislative session, and I'll say it, auditors with guns, maybe a little misleading. We are peace officers, and as such, I want the industry to fully understand that. So any comments? Okay.
Might this be better titled duties of inspectors as peace officers?
Okay. Bob?
I wondered if you wanted anticipating a potential problem with this because all along we've been proceeding under the assumption that, folks are waiving their Fourth Amendment rights, and by participating in this regulatory scheme, the Constitution and the U.S. Constitution as well as the Colorado Constitution are kind of thrown out. But now if the enforcement types are police officers, obviously the police officers here know that, they're subject to the Constitution. They have to follow the Constitution. So we may be putting your folks in a conundrum. And I'm just thinking out loud here right now. I don't have a proposed solution, but it's just something that occurs to me as I sit here. So maybe I'll think about it more and try to come up with some way to reconcile that conundrum, if there is one. Maybe I'm wrong, but it just seems like all along a lot of people are very concerned with, waiving their privacy and that sort of thing during the application process, and my response has always been, well, if you want this license, you've got to waive it. But now, if these people are cops follow the Constitution, or they should anyway.
Okay. Yeah, and I welcome your input and your dialogue. But again, this is something very well found in law in the state of Colorado as well. It's an existing practice in all the other regulatory occupations we're involved with. So, I feel pretty confident where we're headed with it, but I don't want to discount it.
Thank you, Mr. Cook. I think along similar lines as Mr. Corry, and I'm not sure if this is addressed in another part, or if it needs to be perhaps in this section right here, or this rule. The ability of inspectors to enter and to do the inspection itself, I think that perhaps is what Mr. Corry was referring to. Should there be specific language opening the doors to the marijuana centers to inspectors?
There actually is in statute.
Okay.
I believe it's under 601 or 701, I believe.
Good, thank you.
1243.3-701. Don't hold me to that, but that's a good place to start. Norton?
Now, conceptually, the other areas that the department regulates, specifically casino and alcohol, are the inspectors there also similarly armed, and are they endowed with the same statutory powers as peace officers?
Yes, ma'am.
So it's nothing unique to this industry?
It's not. No, it's a very common practice. Gaming industry, the alcohol industry, tobacco industry, dog and horse racing, car dealers, all are similarly situated.
And do they have the power to arrest on
Yes,
site
they
at a casino? Yeah.
Yes, they do. They're all peace officers, post-certified peace officers. Barbara?
Along with that question, though, what is the precedent, for example, if one of those auditors are in a casino and a dealer deals or a bartender provides a drink for someone underage and they haven't been carded? My understanding that protocol is more to the citation side of the business than an individual arrest of that dealer or bartender, or is that not the case?
That's not the case. Yeah, they actually have the ability to enforce all the laws.
No, I know they have the ability. I guess my question is the precedent of what occurs in that business normally. Normally is it that an arrest would occur on the spot, or is the intent to find that employee, find the casino, and not go the arrest route first?
There are two options available to the peace officers doing this, and I'm just going to tell you it's called officer discretion, but I'll explain to you very generically. It's akin to, again, like a DUI. If you're arrested for a DUI, you have a criminal sanction that you must face, and you also have an administrative sanction against your license. And the same is true of any violation of this act. You could technically be charged, as well as the people involved with the violation, with a criminal act, and you could also face an administrative sanction, a fine, a warning, a suspension or revocation of your license, depending upon what the issue is. Again, it's not unique to this industry. It's a very common practice in all the regulated occupations that we do.
From the patient point of view, does any of this impact HIPAA?
I don't believe it does.
Okay. That's one question. That's one question. The patient,
Yeah.
my question